his pay stubs continued to be garnished for child support that he didn't owe.
So I see the Mr. Starr has his firm and his firm has filed a request for recovery of funds that were paid in excess of child support, which is highly unusual and highly different. But obviously, that information is obviously something they can actually ask for. I'm not sure legally I can do anything about it, but again, I can go ahead and take this up, find out what the information is, and then do the necessary legal research to see what I can do one way or the other. Because this is not, while I'm the child support judge, I think I've had this happen twice in the last 20 years as far as the case is concerned. And that one, and those both were a little bit more cut and dry because they were both claiming payment and non-payment and so forth and so on. So at this time, I'll go ahead and ask Mr. Starr for his opening statement to tell the court what he's requesting we do here today, what he understands the circumstances behind that request are. And again, no, not again, Mr. Starr, usually with financial ones, they get really complicated. And I'll, like I said, let you make this opening at this time. But when we're dealing with something where he said, she said, the court may have to reset this for a special setting where we can sit down and that way I can go over proper spreadsheets and seeing everything that we're looking at. But for right now, I'll go ahead and let you make that opening, let the state hear the opening, and then have the state make their response to your opening. And I also need to know at this time, Ms. Hubbard, are both parties present today or just one?
Both parties are present, Your Honor.
All right, then. Thank you. And so at this time, Mr. Starr, I'll go ahead and let you make that opening statement, sir. Thank you.
Okay. So you are correct, Your Honor, that this is a case of overpayment of child support. I don't think there's a he said, she said here. And I think the Attorney General's office is actually in agreement with myself. And we have some exhibits to submit into evidence that will show that my client has, not only did he pay child support that was ordered throughout the time it was ordered, but when his son turned 18 and graduated high school, his pay stubs continued to be garnished for child support that he didn't owe. And that happened up until about September of last year. And so the relevant law here is just section in the Family Code, Chapter 154.012, support paid in excess of support order. And I just want to read that in for the record. If an obligor is not in arrears and the obligor's child support obligation has terminated, the obligee shall return to the obligor a child support payment made by the obligor that exceeds the amount of support ordered, regardless of whether the payment was made before, on, or after the date the child support obligation terminated. And then it also says that the obligor may file a suit to recover child support payment under subsection A if the court finds that the obligee failed to return a child support payment under subsection A. The court shall order the obligee to pay the obligor's attorney's fees and all court costs in addition to the amount of support paid after the date the child support order was terminated. You can waive attorney's fees only if there's good cause shown, and that burden is on the opposing party. And basically what we're asking for, Your Honor, is that you order the overage of child support that my client paid be returned to him, and for attorney's fees, because we've attempted to collect and the overage has been refused. It hasn't been returned.
All right, Ms. Hubbard.
Your Honor, it's my understanding that Ms. Williams is wanting a continuance today to ask for an attorney. It's also my understanding that opposing counsel and Mr. Guy are not in agreement with that. I believe there have been some settings that the Attorney General was not a part of prior to today, and that was the reason why they wanted to proceed forward today. Other than that, Your Honor, the state is willing to offer evidence of our disbursement and our financial record to show that there was an overage, and just ask that the court make an appropriate ruling in this situation.
All right, then, Ms. Williams, you there?
Yes, sir, I am.
All right, Ms. Williams, my understanding is you're requesting a continuance for the purpose of, and I'm not sure whether or not you're asking for court-appointed counsel, or are you asking for a continuance for the opportunity to go out and hire counsel? Because ma'am, I want to tell you up front, I cannot appoint you a legal counsel in this. This doesn't, in Texas, the only thing I can appoint for CPS matters, family violence matters, and criminal matters, and that's it. So any response, any request for that, I cannot grant. But obviously, if you're requesting for the opportunity to go out and hire your own lawyer, I will listen to that at this time, ma'am.
I am, sir.
All right, and ma'am, if I was to, how long do you think you would need for said opportunity, ma'am? Because again, this has been pending for a little while. You've known about it for a little while, but I know lawyers are expensive. I used to be one, and I wouldn't want to pay me what I used to earn back in 2002. So yeah, how long do you think you would need, ma'am?
Maybe 30 days, sir. And I'm only asking for the continuance because I got served this on Friday.
I'm sorry, you got served with the paperwork or something else?
No, the paperwork, sir, was Friday, the 27th of October.
You got served by citation by a process server?
It was the sheriff, I think it was.
All right, Mr. Starr, can you confirm that?
I know she wasn't served for this hearing that long ago, Your Honor, but this case has been going on for over a year, and she's been served prior to that over a year ago so that we could stop the garnishment.
All right,
And
well,
she's chosen
I could do the stop, but that's probably not a problem. But what was she served with most recently, sir?
for this hearing, the paying back the overage
All right, then.
most recently.
Well, obviously, from what I've heard, I can stop the. Are the payments still coming out?
No, they stopped September of 2022.
Okay. Oh, they did stop in September 22, so that's not necessary order. Is there anything on hold from at this time by the state, Ms. Hubbard?
Your Honor, I don't believe the state has any money on hold.
Okay.
It's a special situation because we were a registry only, and I believe that's why there was so much money that accumulated. We show money on hold, but it's not actually still with the state. It's been dispersed.
Okay. All right. Well, maybe get some information about that. Oh, Mr. Starr, since and your office is the one that served Ms. Williams, is that correct?
Yes, sir.
All right. Well, again, sir, she's entitled to 20 days plus the following Monday. So obviously, I got to grant her continuance on that. I would have stopped the money coming out if there was a problem with that. But I understand she got notice of the hearing and everything first. But again, once she was served, she's entitled to that. So, and I may this sounds kind of cut and dry, but I still might want to set this as a special setting, sir. That way you don't have to wait. You and Mr. You and the father and the mother don't have to wait around all day. So let me look at some special setting time frames where I can sneak y'all in and get y'all done in an hour, and y'all don't have to wait around on a general docket. So get your calendar out, Mr. Starr and Ms. Williams. Yep. Get your calendar out. So
mine's more open than Mr. Sikora's is in the other court, so I think we can.
I'm sorry.
I said my calendar is more open than Mr. Sikora's was in the other court that we were in, so
yeah, well,
it worked out easier.
Well, you know, you're the young guy and he's the old guy. Go just and remind him of that, okay?
I do every day.
So yeah, that's the way that works. So, but my kid's been a lawyer for about 5 years now, so he's still the young guy. So yeah, so yeah.
The day he die, he will be, I guess, right?
Oh yeah, still, but I think y'all still have to be members of the Young Lawyers Association until you're. And I'm looking at the calendar at the same time. For the first 5 years of practice, no matter what, right?
Yeah, I think they even extended it longer than that.
Okay, so I know you was a certain age, but we had a lot of people coming into law in their 30s and 40s, and they said you still got to be a young lawyer for at least 5 years. So yeah. All right, let me see my special settings. All right. November. All right, okay, I can start. You don't mind starting one at 12 noon. I've got Monday the 27th available at 12 noon. I got another hearing at 1:30 that day. And you know,
Monday what, sir?
November 27th. Thanksgiving is just really messing with everything before then, but let me go back and see if I got anything on any other date that I can squeeze you guys in. November the 15th. Oh, November the 15th. I've got 9:30 available. So But I'm trying to do the math on her 20 days. That might still not give her the correct amount of time.
The 27th, sir, would work perfect for me.
All right, then. How about you, Mr. Starr?
I have a hearing in Bell County on the 27th.
In the morning?
In the morning, yes, sir.
How about y'all? I know no other judge has hearings at 12 noon, but me. How's 12 noon look at it? It's a Zoom still. So can you do 12 noon on the 27th?
Don't know how long I'll go. That's the problem.
Yeah.
It just temp order if if they start arguing.
All right. Well, technically I got 1:30. The other hearing I have is 1:30 to 4, so I can do 4 to 5 on the 27th.
4 to 5 works great for me.
All right, then. All right, then, man. Would that work for you on the 27th, Ms. Williams?
Yes, sir. Thank you.
All right, then. I'm gonna go ahead and come up do the special setting for this matter on the 27th. We'll have the file by then, and we'll take everything up, and we'll go as long as it takes. Okay.
All right. Thank you,
Sounds
sir.
good.
Both officially under oath. I'm gonna go ahead and let Mr. Starr call you both as witnesses. The state will have the opportunity to cross-examine. And again, at the end of the hearing, ma'am, if you have anything else you think I need to know that didn't come out during your general testimony because you're a pro se litigant, I will allow you to testify to it in a narrative form, so long as it's relevant. So at this time, Mr. Starr, you can call your first witness, please. Thank you.
I'd like to call my client, Mr. Guy, please.
Yes, sir.
Okay,
All right,
Mr.
Mr. Guy,
Guy.
state your full name for the record, sir.
Stanley Allen Guy.
All right, you may proceed.
All right, and Mr. Guy, will you state your son's name in this case?
LeZabrion DeJour Williams.
Okay, and did he turn 18 years of age on December 13th, 2020?
Yes, he did.
And did he graduate high school in May of 2021?
Yes, sir.
And to your knowledge, since your son graduated high school, have you continued to have your wages garnished for the purposes of child support?
Yes.
Okay, and was the last child support payment you made, did that occur in September of 2022?
Yes.
Okay. Now, do you remember uploading to our case management software a document called a financial activity report that you received from the Attorney General's office?
Yes, sir.
All right, to your knowledge, did you alter that document in any way?
Not at all, sir.
Okay. Your Honor, I'd like to submit that document into evidence. I emailed it to you and I believe the Attorney General, but they should have it as well.
You emailed it to Belinda?
Yes, I did.
All right.
State has no objection, Your Honor.
Okay, I must have left it on the bench. Can you go grab it for me, please? Yeah, I'm sorry. I had to move off of the bench and move over here. So
There's also
here it is. It was underneath.
okay. There's also the state disbursement record. We're going to just enter that into the evidence as well. It should
I've got it here.
confirm.
Just a second here. All right, here we go. And so I'm remarking this is respondent father's number 1. All right, folks, I know you can't see it very well, but this is the respondent father's number 1. It is the accounting of the child support that was paid to the state disbursement unit in this case. Is there any reason this should not come into evidence at this time, Mr. Diamond?
No, Your Honor.
All right, Ms. Williams, is there a legal reason this shouldn't come into evidence, ma'am?
No, Your Honor.
All right, respondent father's 1 is admitted. You may proceed.
All right, Mr. Guy, did you see at the end of that document, the Attorney General's office states that you overpaid child support by $13,476.88?
Yes, sir.
Does that amount seem accurate to you?
Yes, sir.
Okay. Do you also remember submitting to our office a document titled Texas Child Support Disbursement Unit Payment Record?
Yes, sir.
Okay, and to your knowledge and belief, was that document altered in any way?
Not at all, sir.
And do you believe the information on that document is correct as well?
Yes, sir.
All right, I'd like to submit that as Petitioner's Exhibit 2, Your Honor.
All right, I'm marking this as respondent father's RF2.
All right, Mr.
All right,
Go ahead.
any objection to RF2 coming in evidence at this time, Mr. Diamond?
No, Your Honor.
All right, Ms. Williams, is there a legal reason that this information should not come before the court this time?
No, sir.
All right, RF2 is admitted. You may proceed, Mr. Starr.
Okay. Since your son graduated high school, Mr. Guy, has Ms. Williams paid you back any of the overage amount of child support?
No, sir.
Okay, would you like the court to award you a judgment, $13,476.88, to make up for the excess amount of child support that has been garnished from your check?
Yes, sir.
All right, and would you like the court to award you attorney's fees since you had to hire me to get this money back?
Yes, sir.
Is there anything else you think the court should hear today, Mr. Guy?
No, sir.
I have no further questions for this witness.
All right, Mr. Diamond.
No questions, Your Honor.
All right, at this time, Ms. Williams, technically you're your own lawyer. I always make have pro se litigants, if they have questions, they have to run them through me because I want to make sure that they're relevant. So at this time, ma'am, as your own legal representative, do you have any questions, Mr. Guy?
No, I don't have any questions, sir, but I do have a statement.
All right, well, that's at the very end, ma'am. Thank you.
Okay.
All right. So, Mr. Starr, you can call your next witness, please.
All right, I'll call Ms. Williams, please.
All right, Ms. Williams, state your full name for the record.
Bertina Levette Williams.
All right, thank you, Ms.
Mr.
Williams.
Starr.
Okay. How old is your son now, Ms. Williams?
He's 20 years old.
All right, and when did he turn 18?
He turned 18 and I think it was 2020 of December 13th.
Okay, and did he graduate high school of May of 2021?
Yes, he did.
Okay, now from September 17th, or excuse me, from September 7th, 2011 to September 27th, 2022, did you receive child support payments for your son?
I did, sir.
Okay, and after your son graduated high school, did you continue to receive those child support payments?
I did.
All right, have you returned any of the excess money since your son graduated high school to Mr. Guy?
No, I have not, sir.
No further questions, Your Honor.
All right, Mr. Diamond.
Yeah, what are the reasons why you didn't return the money, Ms. Williams?
The reason I didn't return them, sir, in December of 2020, I was notified by the Texas Child Support, and they told me that my case was no longer a court-ordered case. And they also told me that my son's father was always also notified. So how did I know he wasn't doing that on his own to rectify or compensate for what he wasn't doing for my child?
I'm sorry. So the point you're trying to make is that his contribution to your son growing up was insufficient, and this was maybe a way of trying to make things right?
Absolutely, sir. Child support only started in 2011. From 2011 before, I was doing that on my own. He chose when to take care of my child.
Okay.
So it sounds like it's an equitable argument that child support didn't go back far enough when it was initiated.
It did not. We have 9 years where I did this solely on my own. I mean,
Objection, non-responsive. This is
All right.
narrative.
All right, here's the deal, ma'am. Yeah, that's not going to fly. Again, this is kind of straightforward. Is there any other reason? I'm sorry, I can't go behind the order of 2011, ma'am. So is there any other reason that you're alleging that happened after 2011 that you should be granted some type of credit for, as far as the overpayment is concerned, ma'am?
absolutely, sir.
All right, what's the reason, ma'am?
Emotional, physical needs. I mean, he was never there for my child. It's more to take raising a child than finances.
Yes, ma'am.
I mean, the medical bills, the dental, all of these things.
Okay, ma'am.
May I ask the witness a few more questions, Your Honor?
Go right ahead.
Are you in good health currently, Ms. Williams?
I am, sir.
And do you have other family members who have health issues?
I do, sir.
Are they close family members?
Sir, I do. We just lost an auntie just Saturday. Yes,
So I take it you help pay for some of the funeral costs?
I do. I have custody of my nephew as well. I lost my sister. I'm raising him as well.
How old's your nephew?
He's 11.
Okay, here's what I'm getting at. You would have to show that it's a hardship for you to repay this $13,000. So is it a hardship for you to repay the $13,000?
It's not, sir, but why should I be obligated to pay something that I feel like I didn't take?
Okay, here's the deal, ma'am. That you feel is not going to meet the legal standard for me to not order this, ma'am. Again, I've got to have some reason at law I know you're not a lawyer, but you didn't retain counsel. I gave you the opportunity to do so, and I've got to hold you to the same standard. And right now, I'm not hearing anything that's going to get you to a legal standard of giving, some type of forgiveness. I'm gonna let the states continue to ask questions, but again, you can't. I've known people for years who they don't do it. They don't have a darn thing to do with their kids. All they do is pay the child support. And I've been saying for years, the only thing I can order is child support. I can order it based on what the law says I'm supposed to do, but I can't make somebody be a parent. That's not within my purview. So unless there's a legal reason, ma'am, that the money, and again, I know you're not a lawyer, but I got to hold you to that standard. Unless there's a legal reason for me not to order it, ma'am, then I'm probably having to look at the order. So is there a legal reason that you know of, ma'am?
It's not, sir.
Okay. All right, you may proceed, Mr. Diamond.
I don't know if there's much more I can add at this point, Your Honor.
All right, then.
So I pass a witness, sir.
Okay, anything on redirect, Mr. Starr?
No further questions, Your Honor.
All right, first off, I got to ask, obviously, we all sitting in here. I don't think, does the state have any witnesses that the state wishes to call at this time?
No, Your Honor.
All right, Ms. Williams, do you have any witnesses you wish to call at this time, ma'am?
No, Your Honor.
All right, at this time, I'll listen to closing arguments, and I'll start with you, Ms. Williams, again. Why shouldn't the court do what the court has been requested to do by the Christian firm in this matter? So, ma'am, thank you. This is your time to make a statement, another statement on the record, ma'am. Thank you.
No further comments, sir.
All right, Mr. Starr?
Yes, Your Honor. I just want to reiterate the law I stated in my opening remarks. 154.012 of the Family Code states that if you make a finding that someone has paid in excess of child support, not only can we bring suit to collect for the overage, but Section B states that if the obligee has not repaid the overage, the court shall order attorney's fees and court costs be paid in addition to the overage. You heard testimony from my client saying that there is an overage. The OAG confirms that there is an overage. He said my numbers were correct. And Mr. Guy has said he's not been paid back. And Ms. Williams has agreed with that assessment that there is an overage and she has not paid it back as well. The overage is $13,476.88. And attorney's fees before this hearing began are $5,808. That would make the total judgment, if my math is correct, $19,284.88. And we would just like to request that amount in our favor, Your Honor.
Okay. All right, folks. Again, this is kind of a straight out accounting one. What I'm going to go ahead and do, I'm looking at having to find, obviously based under the Texas Family Code, that the money that it appears to be uncontroverted, that the funds were paid to Ms. Williams, and they were in excess of the child support amount after the date of graduation and the child turned 18. So the court will reduce the judgment that unpaid amount. I am going to do a 48-hour return on this one, where I can actually see. I need to look up what if it was child support, I know what I would have to do as far as the repayments are concerned, but I'm not sure how this sets up. It's just a straight out judgment, how much I've got to order the repayments to be as far as the monthly amount is. There's still going to be judgment interest on this, and I've got to double check what the standard judgment interest is, because I know the Attorney General and this court has its own interest amount. So I'll have to double check that to see what that is, and that way I can get the make a ruling on what that repayment would be to try to do it over a certain amount of time, if that's also provided for under a normal civil action, and what that amount needs to be as far as covering the interest. And I got to see what the court has to do as far as attorney fees and getting that set up. Is that part of the judgment, or is that something separate? Mr. Starr, do you know off the top of your head, sir?
Off the top of my head, no, I'd have to look it up as well, Your Honor.
All right, here's what I'm going to do. I'm going to go ahead and reset this. Let's see, I think I already got a 1045 on Thursday, and I was going to use this Zoom code, but I'll either do it at 1035 or 1130 on Thursday to see what to get these amounts down pat and see what we're looking at. Okay, no, I do not have a 1045 on this Thursday at the general docket. So what I'm going to go ahead and do is move this Zoom code to that 1045 time slot, and everyone can check in without having to go in through the main docket on that day, which with the 40 or 50 cases we have at that time. So anyway, folks, I'm looking at doing the judgment, but I got to figure out what the repayment amount is, and I've got to figure out what the interest is, and obviously that will be placed in your order, Mr. Starr. And if you can double check that and find that out, I'll allow you to present that to the court at the time, and I'll make the ruling as far as attorney fees going forward. So anyway, I'm taking this under advisement, and I'll see you, and I'm resetting this for Wednesday, November the 30th at 10:45, same Zoom code to make the final rulings on everything in this matter. Is there anything else at this time, Mr. Starr?
I don't believe so, sir.
Anything else, Mr. Diamond?
No, Your Honor.
Anything else, Ms. Williams?
No, Your Honor.
All right, thank you all very much, and we're off the record. Everybody's free to go.
They just recently started taking my child support out when I got my job. My first paycheck, they took child support, and it's like, y'all want me to pay that much, but how am I supposed to survive? I'm working part-time, not full-time. This is the only reason why I haven't had a job, and I took the time to go get a job because I want to do something different. But for y'all to just hit me with this all at once and not giving me a chance to like get on my feet, it's not fair to me.